Hey there, let's revisit some California probate code, specifically a change that went into effect on April 1st, 2025. Yes, April Fool's Day, which somehow feels entirely on brand for what we're about to discuss. Because while you may have heard that California has made it easier to pass on your home after death without a full probate, that's sort of technically true, but it's also not the free pass you might think it is. So let's go over what's actually changed under AB 2016, what it means for families stuck in probate, and why, despite this well-meaning change, the better choice is still a properly drafted and funded living trust. Let's get the foundation set. When someone passes away in California with assets in their name, whether that's a house, bank account, or anything else, and those assets are not titled in a trust or do not have a proper beneficiary designation, then you're going to probate, period. Now, not every case requires a full-blown probate proceeding. California has certain value thresholds that let you bypass full probate if the estate is small enough. Before April 1st, 2025, if a house was worth more than $184,500, you were headed to court for a full probate. Attorney fees, court fees, delays, all of it. Same went for financial assets. But now, AB 2016 has increased the limit with a very important asterisk. As of April 1st, 2025, you can now use a streamlined court process called a petition to determine succession to real property for a primary residence valued at up to $750,000. This means if your loved one died owning their own home, and that home was their primary residence, and it was worth less than $750,000, then yes, you can avoid a full-blown probate. But let's not get carried away. This is not avoiding probate. This is doing a lighter version of probate, really. You still have to get the property formally appraised by a court-approved probate referee, wait up to 60 days for that appraisal, pay the probate referee's valuation fee. Then you're going to file a petition with the probate court and wait another 3 to 4 months just for a hearing. During that time, you're going to pay court filing fees, starting around $450, by the way, send a formal notice to all interested parties, survive the hearing with the judge in the first place, buy a certified order from the court after the hearing because, of course, the court charges for that. What, you think they're going to give you something for free? Then finally, you go and take that certified order from the court down to the county recorder's office, get it recorded, pay for that service, of course, then legally transfer the home. And only after all that can you start collecting any money in the estate. And that's only if there's less than $208,850 in liquid assets, the newly adjusted threshold for a small estate affidavit. So yes, technically it's simpler than a full probate, but it's still months of delay, thousands in fees, especially if you hire an attorney, and a mountain of paperwork, and at the end of the day, none of it guarantees success. Here's the reality. You are not doing anything with a house until the court gives you the green light. So while you're waiting 60 days for the probate referee to tell you how much the house is worth, the mortgage still needs to be paid. Utilities keep running, property taxes keep accruing, and that's all coming out of someone's pocket, likely a grieving family member. And even if the house is valued under $750,000, you still gotta go through the hearing process and get that court order. Then, and only then, can you use a small estate affidavit to collect cash from any bank accounts under $208,850. $208,850. The reason I say you have to wait is because that small estate affidavit is a sworn statement from you under penalty of perjury that there is no probate being conducted, and you technically don't know whether a full probate is going to be required until after the judge issues the desired ruling on the primary residence. And here's where it gets a little messier. If it turns out the house is worth just $1 over $750,000, well, now you're looking at a full probate for everything, house and the bank accounts alike. That means attorney fees based on the gross value of the assets, not the net, longer wait times, and a much more complex proceeding. So let me repeat. While this new $750,000 rule is a helpful relief value, it's not a substitute for proper planning. AB 2016 is not some magical shortcut. It's not a get out of probate free card, it's a reactionary safety net. It gives modest relief to families whose loved ones didn't do any planning ahead of time. It's a patch on a broken system, not a solution. And it only works if there's only one property. That property was the decedent's primary residence. It's worth under $750,000. There's under $208,850 in other assets. And of course, so long as nothing goes wrong. If you don't check every box, or if the referee's appraisal tips the value just a little bit too high, you're headed back to square one and into full probate court along with everyone else. Now, contrast that with the living trust. You sit down with an estate planning attorney and you get to pick who gets what, who's in charge, what conditions you want to set, what happens if someone predeceases you, and how to handle contingencies. You can provide for minor kids, protect spendthrift beneficiaries, stagger distributions, and set rules for specific assets. All of it is done privately, without court involvement. You title your home into the trust now, you name your trust as the beneficiary of your accounts, and when you pass away, your family avoids court, avoids delays, avoids court-mandated attorney fees, and ultimately saves time, money, and stress. And guess what? You're not relying on appraisal deadlines, court calendars, or anyone buying a $50 certified order just to file more paperwork at the recorder's office. You've already done the heavy lifting for your family once on your terms. So let's wrap up. AB 2016 is not a bad law. It's a good relief for those already caught in probate with no plan in place. But don't mistake it for estate planning. It's still court. It's still money. It's still delays. If your goal is to pass your home to your kids to protect what you've built and to make life easier for your family when you're gone, a trust is still the best way to go. If you found this helpful, please give the video a like, subscribe to the channel, and share it with someone who's thinking, I'll just rely on the new rules to get by. Pop your questions in the comments below. I'm Attorney Andrew Bethel, and I'll see you at our next meeting.